Being arrested for domestic violence can be a scary experience. Usually there's a highly emotional situation occurring when police are called to a domestic dispute. Whether or not you're ultimately found guilty of a domestic violence charge, simply being arrested for it will have immediate consequences on your personal and family life. The moment someone is arrested for domestic violence, they're usually issued a no contact, no return order at the jail. That often means that they cannot have contact with their spouse or significant other, and they cannot return home. Judges will often tell people that no contact means no contact. That includes no texting, no phone calls, emails, or even passing messages using a friend or family member. As you can imagine, this is a tough situation, especially when the accused and the alleged victim are partners and they both actually want to have contact with each other. All too often, someone calls the police during a domestic argument and an individual is arrested even if the argument was relatively innocent. Most law enforcement agencies in Central Florida will arrest at least one of the individuals involved in the dispute, even if it's a minor dispute, just to separate the individuals and ensure that nothing bad happens when they leave. The person who gets arrested then goes to jail, has to pay a bond to be released, cannot go home, and cannot contact their spouse or partner, who is the alleged victim. Imagine getting out of jail, not being able to contact your spouse, and having nowhere to go because you can't return home. The only way to fix this is to contact an experienced and qualified domestic violence defense attorney who can file a motion to modify the no contact and no return order, and who can speak to the alleged victim to see if they even want to prosecute in the first place. It's best to hire an attorney that handles these types of cases routinely, knows the system, knows the prosecutors and the judges involved, and knows how to get results. Your attorney should also contact the prosecutor in charge of your case and directly begin negotiating with them to ease the restrictions on you and potentially even drop the charges. Time is of the essence when it comes to a domestic violence charge. The sooner you can retain a qualified defense attorney, the sooner they can begin working to get you the best result possible. If the alleged victim does not want to prosecute, your attorney should help them draft a declination of prosecution, which is their sworn affidavit. The sworn affidavit can be used to undercut the state's case against the accused, to show the state that the alleged victim is not scared of the accused and does not want to prosecute, and to put into a sworn statement that they do not wish the state to intervene into their private life. If the alleged victim does want to prosecute, there's still a number of defenses such as self-defense, lack of evidence to prove the elements of the crime, lack of the ability of the state to prove the charge beyond a reasonable doubt, the alleged victim was not a family or household member, as defined by the statute, or that the crime didn't occur at all, such as a lack of evidence of injuries or third-party witnesses. Furthermore, if incriminating statements were made, we may be able to get those thrown out based on Fifth Amendment grounds, depending on the circumstances. Domestic violence battery is an unlawful touching or striking of a person classified by statute as a family or household member. This can include pushing, punches, biting, grabbing, or even spitting. A family member includes wives, husbands, ex-spouses, individuals related by blood or marriage, such as your sibling or parents, or any individuals living together as a family unit either now or in the past. Even an innocent interaction can lead to an arrest, but just because you're arrested does not mean that you need to roll over and let the system chew you up. If you need help with the domestic violence charge, call my office today. We know the system, we know the process, and we know the characters involved. As a former domestic violence prosecutor, I've seen and handled just about every type of domestic violence case there is. If you're arrested for domestic violence battery, you could face either a misdemeanor or felony charges, depending on how serious the victim's injuries were or whether or not a weapon was used. A first-degree misdemeanor can come with up to 12 months in jail or 12 months of probation, with a fine up to $1,000. If you're charged with a third-degree felony, you could face up to 5 years in prison or 5 years of probation with a fine up to $5,000. On top of that, domestic violence convictions cannot be sealed or expunged, so it's very important that you get a good result in your case. There are minimum mandatory sanctions for this type of crime, such as a 26-week-long intensive batterers intervention course, community service, and other sanctions. In Florida, a domestic violence accusation is one of the most politicized charges in the state. It's very easy for state attorney candidates and all politicians to say that they are harsh on domestic violence because, after all, what voter is going to support domestic violence? But like all politics, sometimes what sounds good on paper and makes great talking points to win campaigns doesn't actually end up resulting in the best outcomes for people, both the accused and the alleged victim. In fact, domestic violence is such a big deal that most county state attorneys' offices have special domestic violence units where they assign some of their best prosecutors to specifically prosecute domestic violence related charges. I should know, because I used to be a domestic violence prosecutor in Osceola County, Florida. I've handled thousands of domestic violence cases as a prosecutor as well as a criminal defense attorney, and I can tell you all about the ins and outs of these cases. All cases are different and no promises can be made, but our track record on defending domestic violence charges speaks for itself. Check out our reviews and what people are saying about us online. If you or a loved one has been arrested for domestic violence in Orlando or Central Florida, do not hesitate in picking up the phone and calling our office today for a free consultation. We'll get to know one another, discuss the unique aspects of your case, and come up with the best strategy for you and your family. Thank you for watching the video. I hope you found the information to be helpful. As always, nothing I said in this video or in any of my videos creates an attorney-client relationship between myself and whoever's on the other side of this video camera.